Good morning. I'm the registrar clerk for this matter. Justice Madlanga, all counsel are online.
Thank you, Mr. Mabina.
I call the matter of Public Protector and Commissioner for the South African Revenue Service and others for judgment. Counsel are now invited to place themselves on record. Please note that this judgment is being recorded.
May it please the court, I am Ms. Nale, and I confirm my appearance on behalf of the Public Protector, who is the applicant in this matter.
Thank you, Ms. Nale.
May it please the court, I appear on behalf of the first respondent, the only active respondent, the Commissioner for the South African Revenue Service.
Thank you, Mr. Pelser. This matter concerns the Public Protector's power to subpoena under the Public Protector Act 3 of 1994, and the question whether that power can trump the proscription under the Tax Administration Act 28 of 2011 of the disclosure of confidential taxpayer information. Also before us for determination is whether an order that the Public Protector must pay de bonis propriis, that is out of her own pocket, 15% of the costs of the Commissioner for the South African Revenue Service must stand. These questions arise in an application by the Public Protector for leave to appeal directly to this court against a judgment of the High Court of South Africa, Gauteng Division, Pretoria. In 2018, the Public Protector issued a subpoena for the Commissioner to appear before her and produce former President Jacob Zuma's taxpayer information. This was pursuant to her investigation into an allegation that former President Zuma was on the payroll of a close corporation known as Royal Security CC. The Commissioner objected to disclosing former President Zuma's taxpayer information on the basis that disclosure is prohibited by the secrecy and confidentiality regime under the Tax Administration Act. The Public Protector took the view that this regime is no bar to her subpoena powers. As a result of this disagreement, the Commissioner and Public Protector jointly briefed Advocate Manager SC to provide an opinion. This opinion was funded by SARS, as the Public Protector said she lacked funds at that stage. Advocate Manager SC gave an opinion, the first opinion, in which he said that there is no conflict between the Public Protector's subpoena powers and the Tax Administration Act, and that the Public Protector's subpoena powers do not include the power to compel disclosure of taxpayer information. The Public Protector did not agree with this opinion, as she felt it did not engage sufficiently with the Constitution. She informed the Commissioner that she would obtain a second opinion. She subsequently briefed Advocate Sekakane SC, who opined that the Public Protector's subpoena powers are constitutional powers that cannot be trammeled by the Tax Administration Act. On the basis of this second opinion, which she did not share with the Commissioner, the Public Protector issued a second subpoena. The Commissioner approached the High Court for an order that SARS officials are entitled to withhold taxpayer information from the Public Protector. The Commissioner further sought a personal costs order against the Public Protector. The Public Protector opposed the application and brought a conditional counter-application for a court order requiring disclosure of the taxpayer information in terms of Section 69(2)(c) of the Tax Administration Act. This section provides that the prohibition of disclosure does not apply where the High Court orders disclosure. Also, in terms of Section 69(6)(b), the prohibition does not apply if the taxpayer concerned has given written consent that the information be disclosed. Relying on this section, the public protector further contended that certain tweets that appeared to have been posted by former President Zuma constituted the requisite written consent. The High Court held that SARS officials are required under Section 69(1) of the Tax Administration Act to withhold taxpayer information, and that the public protector's subpoena powers do not extend to taxpayer information. It dismissed the conditional counter-application, holding that it was procedurally and substantively deficient. And the tweets were found to be inadmissible as their authenticity had not been established. The High Court further ordered the public protector to pay 15% of the commissioner's costs, de bonis proprius. The public protector is now before us, seeking leave to appeal directly to this court against the High Court judgment. The commissioner opposes the application. In a unanimous judgment penned by me and concurred in by Mogoeng CJ, Jafta J, Gampepe J, Majid J, Matopo AJ, Mhlantla J, Theron J, Chikri J, and Victor AJ, the court takes the view that the appeal against the High Court's dismissal of the counter-application does not engage this court's jurisdiction, as it simply demands the reconsideration of the application of uncontroversial legal principles. The court thus dismisses the application for leave to appeal the High Court's dismissal of the counter-application. The primary question regarding the public protector's power to subpoena taxpayer information does engage this court's constitutional jurisdiction. The public protector's arguments require an interpretation of Section 182 of the Constitution, including its relationship with the subpoena powers under the Public Protector Act. Also, these arguments must be viewed with the taxpayer's right to privacy in mind. This too raises a constitutional issue. This is not the end of the matter. Leave to appeal is granted if it is in the interests of justice to do so. And in the case of direct leave to appeal, the interest of justice inquiry includes the question whether there are exceptional circumstances justifying a departure from the normal appellate hierarchy. The public protector's argument rests firstly on urgency. The alleged urgency is grounded in the need to finalize the investigation expeditiously. However, in my view, if expeditiously was any consideration, the public protector would not have gone on a power testing expedition, venturing into unknown, uncertain territory. She could have simply obtained the taxpayer's written consent. From what has been explained to this court, it seems that former President Zuma was willing to provide such consent. And in the unlikely event of consent being withheld, the public protector could have simply sought a court order in terms of Section 69(2)(c). If her reasons for needing the information were cogent enough, and she suggests that they are, this alternative would have been better suited to delivering the desired expeditious results. As a result, I see the urgency argument to be contrived. The public protector's second argument for a direct appeal is that she has strong prospects of success to subpoena under Section 7(4) of the Public Protector Act is part of the constitutional power to investigate under Section 1821 of the Constitution. She argues that her subpoena power is also an additional legislative power contemplated in Section 1822 of the Constitution. She further contends that Section 181(3) of the Constitution compels organs of state to assist and protect the public protector. Finally, she submits that Section 69(1) of the Tax Administration Act does not constitute an absolute prohibition of disclosure of taxpayer information, as it allows a number of exceptions. This prohibition should thus be narrowly interpreted not to apply to the Office of the Public Protector. On this reading, the provision would be constitutionally compliant, submits the public protector. I'll deal with this last argument first. Section 69(1) of the Tax Administration Act provides that SARS must preserve the secrecy of taxpayer information and may not disclose taxpayer information to a person who is not a SARS official. The Act then creates narrow exceptions to this prohibition. The disclosure of taxpayer information in compliance with a subpoena issued by the public protector is not one of the exceptions. SARS officials are thus enjoined to withhold taxpayer information even in the face of such subpoena. Any other interpretation is at odds with the clear wording of Section 69(1). The remaining question is whether the Constitution itself entitles the public protector to taxpayer information. The effect of the public protector's argument is that in the face of the constitutional power she is asserting, Section 69(1) is constitutionally invalid. However, she has not actually challenged the constitutionality of Section 69(1). That being the case, she cannot simply wish away the section and its prohibition. An applicant is not entitled to any relief that effectively flows from the unconstitutionality of an act which has not been declared by a court. Therefore, without a direct frontal challenge to Section 69(1), there are no reasonable prospects of success. Without urgency or prospects of success, the other reasons for seeking direct leave to appeal pale into insignificance. Leave to appeal directly to this court on this issue falls to be refused. I deal next with the personal costs order imposed by the High Court. It is important to bear in mind that the Office of the Public Protector is a constitutional creation. Unwarranted costs orders against the public protector in her personal capacity in work-related litigation may have a chilling and deleterious effect on the exercise of her powers. Because of this likely impact on the exercise of constitutional powers, unwarranted cost orders engage this court's constitutional jurisdiction. And for the reasons that follow, there are reasonable prospects of success on the issue of costs. It is thus in the interests of justice to grant leave to appeal against the personal costs order. I next deal with the merits of this appeal. In making a costs order, a court exercises a discretion which must not be interfered with lightly on appeal. A well-established principle is that a court of appeal should interfere with a costs order only in circumstances where the court below did not exercise its discretion judicially. In other words, it must be established that the court's order was not only wrong, but that as a result of the failure by the court below to exercise its discretion judicially, the court's order did not lie within a range of permissible decisions. Personal court orders against public officials are by nature punitive. To attract such an order, a public official must have displayed egregious conduct or a gross disregard for her or his professional duties. With this standard in mind, did the High Court in the present matter exercise its discretion judicially in ordering the public protector to pay 15% of the commissioner's costs out of her own pocket? The High Court considered a number of factors in reaching its conclusion. I set them out fully. First, in issuing the subpoena, the public protector acted in fraudem legis, a concept that refers to something done to circumvent or evade the law. Second, in first saying she had no funds for the first opinion, but later seeking and paying for a second opinion, the public protector's conduct was in bad faith. Third, other factors that evinced bad faith were the public protector's failure to invite the commissioner to participate in briefing Advocate Sikhakhane SC and not sharing the opinion obtained from him with the commissioner. Fourth, the public protector acted unreasonably, arbitrarily, and in bad faith because she had a, open quote, proclivity, close quote, to operate outside of the law, and a, open quote, deep-rooted recalcitrance to accept advice from senior and junior counsel, close quote. Fifth, it was expected of the public protector to act with a, open quote, high degree of perfection, close quote, and she had failed to do so. I deal with these bases in turn. While the public protector's view that she was entitled to issue the subpoena, regardless of the prohibition in section 69(1) is misguided, it appears to have been a genuinely held view. Based on that genuinely held view, there is no cogent basis for suggesting that the subpoena was issued for any purpose other than the investigation the public protector was conducting. The High Court's conclusion that it was issued in fraudem legis is without factual foundation and constitutes a misdirection on the facts. The public protector explains that the period when she could not make a financial contribution towards sourcing the first opinion fell within one financial year, and the period when she could pay for the second opinion fell within another financial period. That has not been gainsaid, and it sounds like a perfectly sensible explanation. The High Court's conclusion of bad faith in this regard is thus a leap in logic and yet another misdirection. Furthermore, the fact that she lacked funds when the first opinion was sought but had funds for the second opinion does not establish that she acted mala fide. Regarding the High Court's view that the public protector's failure to share the second opinion also constituted bad faith, at worst, she did not act collegially, especially regard being heard to how she and the commissioner had cooperated up to that point. But to infer bad faith purely from a failure to share the opinion is to stretch matters. The public protector was not secretive about the fact that she would seek a second opinion. Had she been acting in bad faith, one would have expected her to be surreptitious from the beginning to end. On this as well, the High Court misdirected itself on the facts. I next deal with the High Court's conclusion that the public protector has a, quote, proclivity, close quote, to operate outside of the law and a, quote, deep-rooted recalcitrance to accept advice from senior and junior counsel, close quote. And before doing so, I must clarify and emphasize that the High Court's conclusion in this regard was about the public protector's conduct in this matter. Some dictionary meanings of proclivity are, quote, a tendency to do something regularly, an inclination, close quote, or a, quote, predisposition towards a particular thing, close quote. What we have on the facts of this case is only the one instance of not being happy with the first opinion and, as a result, seeking a second opinion. How that becomes a proclivity escapes me. Also mind-boggling is the holding by the High Court that the public protector acted outside of the law in seeking a second opinion when she was perfectly entitled to seek it. In fact, in addition to being entitled to seek the second opinion, the public protector acted on the basis of it. Strangely, the High Court regards the opinion of the one senior counsel as gospel and that of the other not. The reality is that the public protector had two conflicting opinions and she preferred one. The correct legal position could have been what was stated in the one or the other or in neither. The High Court's conclusion that by picking the one opinion, she acted unreasonably, arbitrarily, and in bad faith beggars belief and is gratuitous. Finally, the High Court erred in holding that it was expected of the public protector to act with a, open quote, high degree of perfection, close quote. That standard has never been part of our law. If it were, it would follow as a matter of course that each public official who loses a case would be open to being mulcted in costs in her or his personal capacity. That would be so because the very fact of losing a case means the public official would have been found wanting and not to have acted with a high degree of perfection. That would make public service financially hazardous in the extreme. The High Court thus held the public protector to an unduly high and legally non-existent standard. A personal cost order attaches if there is something more than merely falling short of the expected performance by the public official. For example, the public official must have exhibited egregious conduct or a gross disregard for professional responsibilities. There was no such evidence before the High Court. In sum, there was simply no basis for the High Court's award of costs de bonis propriis. The award must be set aside. Ordinarily, I would be stopping here, but I feel I should not. There is a developing trend of seeking personal cost orders in most, if not all cases, against the public protector. The present case and a matter that we decided earlier this year, i.e. economic freedom fighters and public protector versus Godan, are most worrisome on the award of personal cost orders against the public protector by the High Court. As I have just demonstrated, in the present matter, the High Court reached conclusions in which it used epithets and particular nouns, which on the face of it, gave the distinct impression that the public protector was a sure candidate for a personal costs order. But as it turned out, there was not a scintilla of evidence to support those conclusions. Thus, they could not stand up to scrutiny. In the Godan matter, the High Court did not even begin to conduct an inquiry as to what it was that justified a personal costs order. The High Court perfunctorily applied the so-called usual rule on costs, which is that a losing party must pay costs. That, of course, was a glaring error. As I have said, for a public official to be personally liable for costs, there must be something more. I must add that if I am counting correctly, thus far, this court has received 4 matters in which costs against the public protector in her personal capacity were in issue. In three of these, the High Court had made personal cost orders against the public protector. And in one, the public protector's adversary was asking to make the personal cost order. Out of the 4 matters, this court has sanctioned a personal cost order only in one. Courts must be wary not to fall into the trap of thinking that the public protector is fair game for automatic personal costs awards. Considering the chilling effect these orders may have on the exercise of the public protector's powers, including litigating where necessary. Axiomatically, the public protector's office is more important than any incumbent. Needless to say, as the judiciary, we must not be guilty of contributing to the weakening of that office by making indefensible personal costs awards. You weaken that office, you weaken our constitutional democracy. Its potency, its attractiveness to those it must serve, its effectiveness to deliver on the constitutional mandate must be preserved for posterity. These words of caution have not been necessitated by maudlin sympathy for the public protector. Not at all. I am not even saying personal cost orders against the public protector must be made sparingly. That is not the law. I am saying courts must apply the existing law properly and not make personal cost awards where there are no bases to do so. But where the awards are warranted, courts must not hesitate to make them. And the frequency of such awards should not be a curb. In each case, the question is the award warranted? On costs before this court, it seems to me a just order is that each party must pay her or his costs. In the result, the following order is made. 1, leave to appeal against the declarator by the High Court of South Africa, Gauteng Division, Pretoria, that a South African Revenue Service official is entitled to withhold taxpayer information in terms of Section 11.3 of the Public Protector Act 23 of 1994, read with Section 69.1 of the Tax Administration Act 28 of 2011, is refused. 2, leave to appeal against the High Court's dismissal of the Public Protector's counter-application is refused. 3, leave to appeal against the High Court order that the Public Protector must pay de bonis proprius 15% of the tax costs of the Commissioner of the South African Revenue Service is granted. 4, the appeal is upheld and the High Court order referred to in paragraph 3 is set aside. 5, each party must pay her or his costs in this matter. Done the judgment.
As the court pleases.
May it please the court.
Thank you, counsel.
Judgment will be emailed to the parties and will be available online on platforms such as Safely. Today's proceedings have concluded. The host will now terminate the meeting.
Court adjourned.